Hey guys, I'm a little late to seeing this, but Alicia Andrews has filed a motion for a new trial. This was filed on the docket on November 11th, so, a little bit late here, but I am just seeing it now, and we're going to go through it. Let's see what we've got. So, as you guys remember, we last got together for the verdict. After 8 days of testimony and evidence, the jury found Alicia Andrews guilty of manslaughter in the death of Julio, which was a lesser included offense. They acquitted her of the first degree murder, the lesser included of second-degree murder, and then they also acquitted her of the conspiracy to commit first-degree murder. With sentencing, you guys, that's looking to be December 8th. I haven't seen any changes on that, so December 8th should still be the sentencing date. That manslaughter charge has a maximum of 15 years, but because there's also the involvement of a firearm, if that's included as an aggravator, she could be looking up to 30 years from the math that I looked at. Now, meanwhile, her co-defendants are still awaiting their trial. They have not been tried quite yet. But let's go through how this case stands now. So on this first page here, we get into memorandum of law. Quickly, this is just going to say the vehicles, the mechanisms that allow this motion to come forth, and what the codes say can or must be done. So first here with the judgment of acquittal, under Rule 3.380C, if the defense believes the evidence was too weak to legally support the guilty verdict, they can file a post-verdict motion asking the judge to overturn it. There's a 10-day window for when the judgment is filed. Because this was filed on the 11th, that seems to be checked off. Next, we have Rule 3.580. Court may grant a new trial, so this is about the judge's discretion. And in short, that even after a guilty verdict, the judge still has the power. Even if the jury has made a decision, the judge can, on their own or by request of a party of the defense, throw it out, order a new trial if justice requires it. So can't just be all willy-nilly. Next is Rule 3.600, which is the grounds for a new trial. So some things that are reasons for a new trial to be granted. Are there major legal concerns? Was there juror or prosecutorial misconduct? Was something else causing fundamental unfairness? Or is there new evidence? Or is there new evidence that could... We're going to see the grounds that they're arguing below. And the last relevant law here is Rule 3.640, the effect of granting a new trial. And basically, if a new trial is granted, case is going to reset. It's going to be like the first trial never happened. So she can't be retried on first-degree murder or second-degree murder. And she can't be retried on the conspiracy to commit first-degree murder. So a new trial would just be on that manslaughter and any applicable lessers that might attach to that. So let's get into their argument. And now we're going to read through it straight. So the argument, their first argument here. What are the grounds? What do we think is the reason that a new trial should be granted? So first, the verdict is contrary to law or the weight of the evidence. They say a new trial is warranted where the verdict is against the manifest weight of the evidence or contrary to applicable law. And they cite the Florida Rule of Criminal Procedure 3.600A2. So here, the jury's decision to acquit Miss Andrews of first-degree murder, conspiracy to commit first-degree murder, and second-degree murder made it evident that the state failed to prove that Miss Andrews either intended for the crime to occur, or that she did some act or said something that was intended to, and that did incite, cause, encourage, assist, or advise the other persons to actually commit the crime. If either of the two principal elements are missing, the jury could not find that Miss Andrews committed manslaughter as a principal. However, the jury incorrectly rendered, and this is what they're arguing, a verdict that was contrary to the law and the weight of the evidence. So here they're going to cite here a District Court of Appeals, the Second District Court of Appeals case from 2002, Geibel v. State, that in deciding a motion for a new trial pursuant to the same rule, or really 3.600B, on the ground that the verdict is contrary to the weight of the evidence, the trial court acts as a safety valve by granting a new trial where the evidence is technically sufficient to prove the criminal charge, but the weight of the evidence does not appear to support the jury verdict. Miss Andrews did not act as a principal to a manslaughter. Charles Jones was not killed by a negligent act. There is not adequate evidence in the trial record to show that Miss Andrews caused the death of Mr. Jones by some culpably negligent act. The state's theory was that Miss Andrews was a fully informed, so all of the intent, the fullest degree of intent, was the state's argument, in the intentional and well-planned murder of Charles Jones. Nothing about the state's presentation of evidence suggests Miss Andrews' acts were the product of negligence. Thus, the jury's decision to convict Miss Andrews of manslaughter is contrary to the weight of the evidence. Next argument here. So the court erred in rulings on matters of law, including refusal to give proper defense instructions. It is well established that a defendant is entitled to have the jury instructed the law applicable to their theory of defense, where there is evidence introduced thereof. And I cite here Motley v. State and Bryant v. State. The Florida Supreme Court has articulated a three-part test for special and jury instructions, requiring that 1. Special instruction must be supported by the evidence. 2. The standard instruction does not adequately cover the theory of defense. And 3. The special instruction must be a correct statement of the law and not misleading or confusing. And then also citing here Stevens v. State, the court held that a defendant is entitled to a jury of instruction on his theory of the case, if there's any evidence to support it, no matter how flimsy that evidence might be. Here, the defense requested the following special instructions be added to the principal jury instruction. Mere presence at the scene, including driving the perpetrator to and from the scene, is not sufficient to prove that the defendant intended to commit a crime. A display of questionable behavior after the fact is not sufficient to prove that the defendant intended to commit the crime. And knowledge of the crime after it was committed is not sufficient to prove a conscious intent of the crime. These instructions satisfied the Stevens test because they were supported by the evidence introduced. They were supported by the evidence introduced at trial. Maybe I was going to say in the record, and they changed it to the way they worded it here, and they left some words. The standard instruction did not adequately cover the defense's theory, and the special instructions were a correct statement of the law and not misleading or confusing. So first, they're going to tackle it prong by prong. First, the state's evidence showed that Miss Andrews was merely present at the scene and that she was in her co-defendant's vehicle during the night of the homicide. Thus, there was substantial evidence showing that Miss Andrews was merely present at the scene of the crime, and the first prong was met. Second, the standard instruction did not include the language the defense requested in the special jury instructions. Thus, the standard instructions did not adequately cover the theory of defense. Lastly, the special instruction was a correct statement of the law and was not misleading as the language was taken directly from binding case law. And they say, see Penny v. State, the 2nd District Court of Appeals, October 1st, 2025. It's pretty recent. The 4th District Court of Appeal found reversible error where the trial court refused to give an afterthought of instruction in a robbery case. They're citing here Perkins v. State. The court held that, quote, the failure to give a requested jury instruction on a key theory of defense, where there is evidence to support the instruction, requires a new trial. The standard robbery instruction was inadequate because, without the instruction as requested by appellant in this case, or as given in Perry, the jury could not have understood the afterthought theory of defense. Gary v. Florida, reversing a conviction where the trial court refused to give an independent act instruction. Next argument here. So this one has some sub-arguments. The trial court improperly denied defendant's challenge for cause against a prospective juror. There is a two-pronged standard requiring an appellant to establish both error and prejudice to be granted a new trial based on a trial judge's denial of a cause challenge, thereby forcing the defendant to use a peremptory challenge. So first, we have there was reasonable doubt as to whether a juror possessed an impartial state of mind. So what's going on with this juror? The test for determining juror competency is whether the juror can lay aside any bias or prejudice and render a verdict solely on the evidence presented and the instructions on the law given by the court. A potential juror must be excused for cause if there's any reasonable doubt as to whether the potential juror possesses an impartial state of mind. A potential juror must be excused for cause. A potential juror must be excused for cause if there's any reasonable doubt as to whether the potential juror possesses an impartial state of mind. So we've got Bryant v. State and then Hill v. State. And in parentheses, providing that if any reasonable doubt exists as to whether a juror possesses a state of mind necessary to render an impartial recommendation as to punishment, the juror must be excused for cause. So what happened at trial? The trial court erred when it refused to grant Miss Andrews' challenge for cause against multiple jurors, including but not limited to jurors number 6, a former representative and sponsor of tough on crime legislation. Juror 6 made it very known that he was and still is a staunch supporter of legislation that increased the amount of time that convicted felons spend in prison. Juror 6 transparently shared his personal beliefs and professional efforts as they relate to sentencing and due process. In his career, Juror 6 sponsored significantly harsh legislation geared at reducing the time that inmates spend on death row, ultimately minimizing a defendant's ability to seek appellate relief after trial. Yeah, you narrow that time window, Because listen, there are some wrongful convictions, exoneration stories where it's 10 years, 20 years, 30 years, 40 years, and someone's conviction's overturned and they're exonerated. So when you narrow that window for a death penalty case, Juror 6 expressed little to no interest or previous support in legislation to the contrary. As this is a case where a life sentence was a genuine possibility, Ms. Andrews asserts that Juror 6 presented reasonable doubts as to his impartiality. His prior experience and views presented a reasonable fear that the jury would be exposed to the potential consequences of a guilty verdict and improperly influenced in their deliberations. Despite the defendant's efforts to exclude Juror 6 for cause, the court denied the request, and ultimately, Ms. Andrews was forced to use a peremptory challenge to remove jurisdiction from the venire. The court denied several other defense cause challenges that had merit. The next argument under this grounds is that the defendant was prejudiced by the court's failure to grant an additional peremptory challenge to the defense. Since Ms. Andrews was unable to use a cause challenge to exclude Juror 6, Ms. Andrews was ultimately forced to use a peremptory strike against Juror 6. The forced use of the defense peremptory strike on Juror 6 and other jurors who should have been struck for cause resulted in the defense having to accept Juror 62, a juror that the defendant would have used a peremptory strike on, if granted by the court. During voir dire, Juror 62 explicitly asserted his inability to understand rap lyrics, an issue that turned out to be a central part of the state's case against Ms. Andrews. Based on that inability, the defendant believed Juror 6 would not be an appropriate juror in the present case, and the defense would have used a peremptory strike against him should the court have granted it. Juror 62 ultimately sat as a juror in the trial. Thus, Ms. Andrews will likely be able to show error in the jury selection process, and there's no ending here. There's no period, but it seems like they're going to request a hearing. Let's see. Defendant was denied her right to a fair and impartial trial. Even if no single error warrants reversal, the cumulative effect of the errors deprived defendant of due process and a fair trial. We've got McDuffie v. State. In addition to the issues mentioned above, 2 of Ms. Andrews' witnesses were not allowed to testify to relevant evidence in this case, an independent ground for reversal. I would assume that this is referring to the friends that were going to speak to the toxic relationship. We've got Walker v. State here, and in parentheses, reversed for new trial because trial court excluded witness testimony that was otherwise relevant evidence. And conclusion, so what do we want? Wherefore, Ms. Andrews respectfully requests this court grant this motion, set this matter for a hearing on the issues addressed herein, and after hearing argument, enter a judgment of acquittal notwithstanding the verdict pursuant to Florida Rule of Criminal Procedure 3.380C, or, in the alternative, grant a new trial pursuant to Rule 3.6A. And for any further relief the court deems just and proper. So we've got this signed off on by Jeremy McLyman, and that's the only signature I see. And there you go. There is our November 11th motion that I am catching. It feels like so late. But I wanted to go through that. Again, trial court level, this is going to be Michelle hearing this. If this is denied, I would imagine adding whatever other enumerations of error, and you'll see an appeal brief filed perhaps. Sentencing's on December 8th. So, I don't know. Between then and now, maybe the state will respond to this motion. We'll get together. We can do something on that if I see that hit the docket. Or stay tuned for December 8th for sentencing. Again, hope everyone's doing well. Thanks for tuning in. Hit that like button and see you next time. Bye-bye.